Is Matt Kohn, and I'm here with Justin Wales, and together we co-chair the blockchain technology and virtual currency practice at a law firm called Carlton Fields. We're both based out of Miami, though Justin spends a lot of his time in LA, and I tend to be up and down the eastern seaboard. As a firm, we're somewhere between 400 and 500 lawyers. It fluctuates day to day, and we've got offices all over the nation, including here in Atlanta, so we make our way up this part of town relatively often. And we've been doing a lot of exciting stuff in the blockchain space for many years, and it's been a passion project for Justin and I for a long time. I personally found Bitcoin sometime back in like 2011 and was mystified by it. I remember being in the room in 2014 when Vitalik Buterin started talking about building this thing called Ethereum and was further blown away, and it's really been a passion project ever since. And it just so happened that this crazy blockchain technology that we all know and love has some very unique problems when it interacts with the law. And today, we're going to talk about something you've probably not heard before. And it's I think, going to offer a little bit different flavor than you're used to. And so to give you a little bit of background, I'm primarily a corporate lawyer, meaning I work with businesses and companies doing all sorts of things I find interesting, you may find boring. That goes from company formation to raising capital to mergers and acquisitions and that sort of thing. As a practice, we do a lot of work with blockchain companies in all sectors of the space. So from, for example, the regulatory perspective, we advise companies on money transmission laws, whether they are exchanges, ATM providers, OTC desks, cryptocurrency brokers, you name it. We've been called on to issue securities advice to token issuers. That's both people interested in doing what we now often refer to as a utility token and what the contours of the law are there. And then, of course, security tokens, or if, as you saw in the last presentation, things like asset-backed tokens, where you're actually tokenizing a piece of real estate or what have you. We've also worked with protocol core developers, right, on what some of the more arcane issues of protocol developer liability could be, or maybe should be. We've worked with legislatures on helping lawmakers to understand this technology and where it fits within the grand scheme of things and how it interacts in commerce. And so it's been a really interesting couple of years, and we're excited to see where this space goes. And as part of these different things that we're involved in from day to day, we encounter all different types of law in the United States, and occasionally outside the US. The beauty of this presentation today is that Justin, who's going to be talking in a moment, is a bona fide constitutional lawyer. It's a really rare breed, right? And so typically, if we're looking at this pyramid here, when you're talking to a lawyer, you're usually asking about the bottom two steps of that pyramid. So that's if we're taking the middle, your regulations, that would be something like, how do I issue a token in a compliant manner and that's consistent with the securities laws? Or how do I engage in money transmission without winding up in jail for being unlicensed, right? That's where we take the regulations and we apply them to your business model, and we often have to look at that bottom rung guidance that these regulators issue and determine if what you're doing even implicates these rules and regulations. Where we are starting to see some development is in the laws, right, which is the next rung up the pyramid, which is what I'll call what the legislators are doing. So you've seen bills like the Token Taxonomy Act introduced in the Congress at the federal level. We've seen a bunch of wacky things, frankly, happening at state levels, but interesting nonetheless. But one thing that's not often talked about is the U.S. Constitution. And you're probably thinking, well, I'm familiar with the First Amendment, the Second Amendment, and what have you, and none of them mention, the right to keep and bear a blockchain, right, or something like that. But there are some constitutional implications for this technology, and I think it's really exciting. And as the technology has advanced, we've been called on to explore some of these issues in relatively important capacities, right, where, not to go too into the weeds on what Justin's going to talk about, but when do you have a fundamental right to be associating with others in the use of a technology? When is code protected by the Constitution? Things like this, right? So we're no longer out in the realm of regulators and regulation and guidance, and now in the realm of, what does the greatest law of the land, the very top of this pyramid, allow me to do, regardless of what a law or a regulation might say. And this is some of the most exciting, in my opinion, stuff to happen in this space. And I think it's going to, as time goes on, we're going to see blockchain, particularly Bitcoin and some of the larger blockchains, interact with the Constitution and the cases the progeny of cases that have sprung out of it. So with that, I'm going to turn you over to Justin, who is going to give us a primer on the First Amendment and explain why we all have a fundamental right to use the Bitcoin network, or at least something like that. So, Justin?
Hello? Okay. I think it's maybe important to start with why I started exploring this topic. It came as sort of a result of speaking at conferences like this one and conferences with, I guess, less substance. This is a conference of substance. I've gone to a lot of conferences without substance and being on a lot of legal panels. And in every case, I think I counted the other day, and I was on something like 50-something legal panels over the last year, and every single one dealt specifically with minutia of securities regulations, with the minutia of money transmitter rules, with broker-dealer issues, and in many ways, it just, I think, missed the picture of how we describe this technology and how we describe what this technology can do. And that has really serious, I think, implications for how this industry grows. Now, why is that? It's because we don't know the extent of how the blockchain, and when I say blockchain, I mean specifically the Bitcoin blockchains or blockchains with similar sort of open, decentralized characteristics, how this will affect all sorts of aspects of society. And I wanted to start with just a quote. This is from a case from 2017 from the Supreme Court. And they're actually cribbing language originally by Benjamin Rush, who was one of the signers of the Declaration of Independence. And it says, the nature of a revolution in thought can be that in its early stages, even its participants may be unaware of it. And when awareness comes, they still may be unable to know or foresee where its changes leads. Now, that was originally written in response to the American experiment of democracy. In 2017, Justice Kennedy quoted it to talk about Facebook in an opinion that was underreported, but what it basically said was, we all have a fundamental First Amendment right to associational networks, including social media. And it was a warning to future generations of the court. Kennedy retired shortly after. Not to view technology as the technology before you, but to really think about what are the implications of all sorts of technology that's to come. And in a bit, I'll talk about a case that came out of Florida just 3 days ago that really makes things difficult for people who want to transfer Bitcoin from one to another without registering with the government, and doesn't really follow this type of principle. But this was applied to democracy, this was applied to social networks. I would argue that this is also going to be applied to blockchains and all sorts of other, what I would call expressive or communicative technologies. So the sorry state of crypto law, I'm sure everyone who's at this conference has been to tons and tons of conferences. And in each case, you've probably seen several legal panels. And the legal panels have always been focused explicitly on regulation, mostly by regulators or regulatory attorneys. Now, Matt and I do a lot of regulatory law, but I think we approach it from a different perspective, or at least I do. I mean, Matt to a lesser degree because he doesn't have this background in the First Amendment, but my background is specifically in the Constitution. Before we started this, the firm's blockchain virtual currency practice, I was exclusively a constitutional lawyer in the firm's litigation department. We worked on really fascinating cases. We represented really large media companies. We overturned statutes at both the state and federal level, including gay marriage bans in Florida, and we were involved in the briefings for the Supreme Court gay marriage decision several years ago. And it's all I ever wanted to do. From when I went to law school, I went to law school specifically to be a First Amendment lawyer. And I think the way I first interacted with Bitcoin is a good example of how I view the technology now. If some of you recall, the Obama administration had put pressure on all sorts of payment networks, MasterCard, Bank of America, Wells Fargo, et cetera, to not allow any donations to WikiLeaks. So what was the response from Julian Assange? He put out a tweet and said, if you want to donate to WikiLeaks, donate through Bitcoin. And I remember I was sitting in the law review office at my school, and I remember saying, like, well, what is Bitcoin? Why would that work? And from there, I understood that, oh, this is more than money. This is not really money. This is a form of expression. This allows me to have a communication that's not censorship. It's a resistant technology that allows the government to, it puts a barrier between a person and two people that the government can't get in between and say, well, this type of donation is good, this is bad, this type of speech is good, this type of speech is bad. So as a result of lawyers specifically focusing on the how do we operate a business without getting a money transmitter license? How do we sell a token without it becoming a security? We're focused on such a micro level, and that is, here's my joke, that is why crypto panels are often so boring. Now, as Matt said, there is a hierarchy of laws. We're going to be focusing on the US Constitution here because the best basis for overturning a law or for arguing that a law shouldn't apply is not that it was wrongly decided by a regulator, but it's because it's fundamentally at odds with the very principles of our country. Now, the First Amendment, I just want to read it because it's broad and it includes a lot of different types of rights, but Congress shall make no law respecting an establishment of religion, we're not really going to talk about that, or prohibiting the free exercise thereof, that's also sort of a whole other separate topic, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now there's a lot of law and a lot of rights included in that little amendment. And as we'll see as we go through, a lot of them could potentially apply to this technology. Now, let me say here. So why do we focus so much on regulation? And it's because this technology is hard to describe and it's hard to understand, and part of it is just how we name it. So we call it Bitcoin, we say it's digital gold, we say it's virtual money, we say it's a peer-to-peer electronic cash system, or electronic cash, that's Satoshi's own language. Now, if I'm a regulator and I'm being asked, and I'm not a technologist, I haven't been to 1,000 of these conferences, and this hasn't been my obsession for a decade, and someone says, oh, well, these people are money laundering with digital cash. Well, okay, I know how I would prohibit money transmission. I know how I would prohibit commodities fraud. I know how I would prohibit securities fraud. I often hear it, a woman who was cutting my hair, I asked her if she knew what Bitcoin was, and she said it's like a stock. I know, if I'm a regulator, I know how to deal with stocks. So these are all analogies that we use to describe Bitcoin, but Bitcoin is none of those things. What is Bitcoin in reality? So this is sort of my best interpretation. An open global network that allows participants to create indicia of data control that is authenticated without reliance on central validators through utilization of complex cryptography and a game theoretical proof of work reward system. What does that mean? It's counterintuitive for us to even understand that because the easiest thing for us to understand is, oh, it's like digital gold, right? It's like e-cash, okay. But it's not. It's more like the internet, but it uses the internet. It's a confusing type of technology that regulators, frankly, are not fully comprehending. And the reason they're not fully comprehending, and this is a problem with the legal community working in blockchain is because the lawyers are using these analogies in panels and in presentations to say, well, yeah, it's a store of value. It's a cash system. But it's something more than that. And what I want to do in this presentation is talk about what money is, how money has always been a technology, and then how specifically the Bitcoin blockchain can be used for all sorts of communications that are non-financial. And once you sort of understand all of that, and then we'll talk about principles of First Amendment jurisprudence and why we have a First Amendment and all sorts of interpretive models, I think it'll be very clear that a lot of the regulations we're seeing proposed at the state and federal level are potentially overbroad and infringe potentially on a lot of rights. So let's talk about specifically what is money. Now, I would argue that money is what Bitcoin does, and it is not what it is. There's a book that I think everyone who's in this industry should read. It's called Debt, The First 5,000 Years. It might be the most influential book in crypto. It was written long before Bitcoin came out. But what it does is it traces sort of the identity of monetary systems and how it has always been used throughout history and time immemorial as an expression of debt rather than an expression of value. Now, there's some controversy within sort of the financial communities whether that's true, but I think David Graeber, who's a really brilliant guy, lays out a good example. But one of the things that he talks about is money has always been technology. And when you think about the different types of money that has been used throughout history, you can see that as every type of form of money has evolved, our uses and our ability to interact with each other has changed. So you can go back and you think, well, it used to be sort of stones, and then there was feathers, and there was salt, and then there was greenbacks, and then there's coins. And each of those were money to a community. We all agree that, okay, these little circles of metal are going to be worth something, and these circles of metal are going to be jewelry. Well, we just agree to that. And the reason why we pick coins instead of stones is, well, they're easier to transport. Every type of technology that we use as money throughout history has had its benefits and its detriments. So what I would argue is that, sure, Bitcoin is just the latest form of money because it is just an abstraction of value. Every type of money that we've ever seen has just been an abstraction of value and a way for me to say to you that I value you X amount or I value this product X amount according to a system that we've already agreed upon. Now, with Bitcoin, the mean is the median. This is actually from Andres Antonopoulos. He said that in a speech, and I think I agree with it. Because what Bitcoin does is it takes the cost of production of money and makes it so low that it allows us to interact in ways that were never before humanly possible. And we're going to talk a bit about like the Lightning Network and what's happening right now with this Lightning Trust chain that I don't know if anyone's been following on Twitter, but to me this is like an amazing, amazing breakthrough. And why is it? Is because right now under our current system, if I wanted to say that I value you, the least that I could value you is 1 penny. And that would be in person. But if, let's say I wanted to value you on the internet, it would be far higher because I would have to also pay for the cost of actually sending that transmission. So if you allow, with micropayments, for me to send you, I think the lowest amount that I can send on Lightning is 1/236th of a penny. Well, that's a whole new level of communication and expression that I can now make through this technology that I couldn't make before. And that implicates all sorts of First Amendment rights. Now, this next slide may be controversial to some folks in the industry, but Bitcoin can be used for all sorts of things that are not financial at all, including publication. Now, there are images published onto the blockchain. This is actually sort of one of the reasons why there's like a Simpsons theme in this presentation is because this is an actual image someone published onto the Bitcoin blockchain. Mr. Burns saying, "Don't forget you're here forever," sort of a play on the immutability. You have these ASCII art memorials that have also been on there. Other examples of completely non-commercial expressive data stored onto the blockchain immutably are Bible verses that have been published by Christian missionaries. You have an MP3 recording of Spock saying, "Live long and prosper." You have all sorts of critiques of various governments. You also can use the blockchain for record keeping. You can use it for authentication. I mean, this is sort of what Tyrion is doing, right? You can validate things directly peer-to-peer using, basically leveraging the Bitcoin blockchain that is completely non-commercial. I could actually take a hash of this presentation, burn a minuscule amount of Bitcoin. It's non-financial, I'm throwing the money away, just so I can prove that I put, that I was in control of this document at the time that I put it onto the blockchain. Color coins is another great example, sort of leaning into the fact that Bitcoin is not technically a fungible asset. You can trace the provenance of every single coin back to its genesis. So what you can do is you can build systems on top of that that allow you to create indicia of ownership on separate systems. So for instance, I could have a Bitcoin. That Bitcoin might be tied to ownership of my car. If I send it to Matt, well, now he has title of the car, or as a base level, the value would never drop below the price of Bitcoin. You're also seeing projects like Rootstock, RSK, which is trying to leverage the entire Bitcoin blockchain to do all sorts of smart contract applications. And then the microtransactions on the Lightning Network allow for all different types of other communications that are essentially non-financial. An interesting use case, and I think Samson, I don't remember who it was, but I think it might have been Samson Mao, posted a thing to @Jack the other day about creating the ability to send microtransactions on Twitter to reward people for tweets that they like. Well, if you sort of extrapolate what that could mean, you could have a Reddit where instead of upvotes, you're using microtransactions. You're sort of paying people for their content. It might be very small amounts, but it becomes a good way of seeing how it's not a commercial expression. It's just a non-commercial way of saying that I agree with what you're saying and want to support it. So I go to a lot of First Amendment conferences as well, and one of the things I have a critique of, like, the First Amendment lawyers is that they assume everyone understands why we have a First Amendment, and it's a controversial, actually a controversial topic, because there are a number of interpretive models of First Amendment jurisprudence as to how do we take the text of the First Amendment, which was written hundreds of years ago at a time before any of the technology or any of the types of interaction that we now have to regulate existed, and how do we apply it to these new technologies? So I want to go through several of them. The first one is sort of an overarching judicial principle, as Scalia was actually the most sort of prominent First Amendment originalist. And then the others are sort of reasons why the First Amendment sort of has come to bear. But the first is First Amendment originalism. And what originalists believe is that you look to the actual text of the Constitution, but not really. If you actually look through sort of the writings on what originalism means, because if you look just to the text of the Constitution, you'll never be able to apply anything to anyone. So what they really say is you look at the words of the Constitution as understood by the ratifiers of the Constitution at the time of ratification. Now, that's an insane model for a number of reasons. First, the ratifiers of the Constitution were such a small group of people, even relative to the size of the country at the time. So during the ratifiers of the Constitution did not include black people. They did not include women. They did not include, in most cases, men who didn't own property. I think, I don't have the number, but I think New York had something like 34 ratifiers. So you're trying to now interpret language of the Constitution to apply it based on what those ratifiers understood at the time of ratification. It's an impossible task, and it gets even harder when you consider that none of the ratifiers had a solitary view of what the words even meant, and that's because the idea of freedom. What does red mean?
Means keep going.
Oh, am I out of time? It's a 1 hour. Oh yeah, okay. I was say we're just getting started. Okay, yeah. I was on such a roll too. All right. Yeah. Okay. So, threw me off. So, the ideas of freedom of expression, for instance, were not commonly used words even at the time of ratification. These were terms of art that were created by the drafters. So to say, well, what did people in the 1700s think of freedom of expression? They wouldn't have any idea what you were talking about, because the concept was just a rhetorical flourish at the time, and now we're trying to make headway of it. So the idea of First Amendment originalism has sort of like been something that a lot of conservative jurists sort of talk about, but no one really follows it because it's an impossible task. So that you use it to justify a position that you already have, usually. What Scalia ended up advocating for is basically you sort of look at what the ratifiers might have believed, but you acknowledge that the Constitution is a living document, it can be malleable, and you try to apply it to different types of situations that were not possible to apply to back at the ratification. So that's why you're able to apply the First Amendment to all sorts of technologies like radio, TV, the internet, even though the Constitution doesn't mention any of those things. So one of the more popular theories of First Amendment interpretation of why do we have a First Amendment is this marketplace of ideas theory. Oliver Wendell Holmes is probably the most famous Supreme Court justice to advocate for this theory, and John Milton, the philosopher, wrote quite a bit about this. And the idea is that the marketplace of ideas needs to be protected from government interference. So to the extent that you and I or whomever have some sort of technology, some sort of relationship whose core purpose is to advocate for new ideas, you can't have the government coming in and saying, well, we don't like those ideas, so we're going to make it very difficult for those ideas to spread. So the marketplace of idea theory has been used to overturn quite a number of regulations that would stifle speech. A lot of them in the 60s and 70s related to the extent to which the government can regulate the press. There were a lot of press cases back in the Burger Court. The third is this thing called the checking value theory of First Amendment. And it's a professor from really the 70s named Vincent Blasi. And he said the First Amendment was created as basically a check on the government. So this is the idea of like the fourth estate, right? The press is there to make sure that the government is not acting out of lines. So you've seen all these sort of derivative rights become recognized, including the right to newsgather, the right to anonymous speech in many instances, the right to receive and obtain and inspect judicial or public records. These are all based on the idea that the public needs to have access to the information that the government is creating and needs the ability to speak out against the government in order to serve as a democratic check. There's a professor out of Yale who's, if you're in like real hardcore constitutional circles, his name's Akir Amar. And he's one of the more prominent constitutional scholars of like modern day, and he has a book called The Constitution, and it goes through every amendment, and it talks about, well, why was the First Amendment created? Why was the Second Amendment created? These were all created as sort of an ancillary check on our check and balance system, and I think it makes quite a bit of sense if you read through. There's an interpretive model called the political speech theory. And the idea here is, well, the First Amendment really only protects speech that can be directly linked to democratic concepts, to politics. Now, the Supreme Court, in a case that my mentor actually worked on called Miami Herald versus Tornillo, actually said that this was not a theory that they believed in. It was Robert Bork. I don't know if you guys remember him from probably like high school history class or like CNN documentaries about the 80s. But he was a super conservative guy. He was nominated for the Supreme Court, and it got his nomination got rejected because he was sort of a controversial guy. He was an advocate of this political speech theory. He was a poet and philosopher named Alexander Michael John. He was originally an advocate of this theory, but ended up sort of retreating from it. And I'd like to explain why. It's because it's very hard to find the line of when a form of expression is political or non-political. So for instance, this is like an example I like to use. The movie Get Out, which I assume some of you have seen, but you can also apply this to Clockwork Orange or To Kill a Mockingbird or whatever. Is that political speech? And I could argue that it's just like a horror movie, right? I mean, I could watch it and just, oh, it's a horror movie and it's entertaining. Or I could say it's like a satirical reflection on liberal white America's relationship to African Americans. Now, if I describe it one way, it becomes political, and it would arguably be protected under political speech. If I argue that it's entertainment, well then it arguably wouldn't be protected under this doctrine. It becomes a standard that you just can't apply, and that's one of the reasons why the Supreme Court has said that we don't recognize it under our own jurisprudence. And then finally, the liberty and autonomy model. And Edwin Baker is probably the biggest advocate for this one. And it's that the First Amendment is to allow individuals to be autonomous from government interference, right? And if for the people in this room, everyone here is like pretty familiar with Bitcoin, is pretty familiar with like the reasons why it was created. You could apply each of these theories to this type of technology and understand why it is protected and why these First Amendment principles apply. But in order to do so, sort of going back to like the slides from before, what do you have to do? You have to acknowledge that this is much more than a digital money. This is a network that we're all participating in order to have liberty and autonomy, in order to convey a political message. I mean, the Genesis block itself conveyed what? A political message, right? Chancellor on the brink of second bailout with the banks. It's a check on centralized governments. It allows for people to express different types of ideas in a way, either through something like the Lightning Network, where I can now express value in a way that was previously impossible, or just the fact that I don't think that a centralized bank should have complete control over our currency. So now I want to talk about this idea of Bitcoin is speech and also the associational rights. And I think this is where it really actually clicked for me, this whole topic, is when we were first experiencing the fork wars, right? When I was seeing what was happening with Bitcoin, and Bitcoin Cash is being split, and Bitcoin Cash is being split to BSV, and you were seeing ETH being split to ETH Classic, and all these things, and it just didn't make sense to me that, okay, Bitcoin's a currency, fine. And then you split it into another currency, and then you split it into another form of money, and you split it into another form of money. Well, if you just have an unlimited amount of forms of money, then that's not money, right? Money has to have some backing. Fiat makes sense because the government is saying, this is what we accept for taxes. We are backing it up. We have full faith and credit. It's going to be backed by a gold supply controlled by governments. But if I, as an individual, have the ability of spitting out 1,000 forms of money, well then the idea of what money is to a government just makes no sense, right? It's nothing. So what is it really? It's one group of people. And we sort of talk about this in technological terms, but the Bitcoin network is at its core an association of individuals. Now these might be individuals as corporations in some cases, but the Supreme Court has said that corporations are people, so that's fine. But you have the Bitcoin core people have an infight, And then some of them say, I don't like the way you're governing things. I don't like your ideas. I'm going to spin this out to Bitcoin Cash. And the Bitcoin Cash folks have an infight, and they say, you know, I don't like the way you're governing things. I'm going to split it out to something like this, and you can do this all day long. Now, what is that? That is just a group of people deciding that we are going to, as a democratic community, decide who has, you know, where all of our allegiances align. So I think the evidence of the various forks and all the different splits demonstrates that these are networks and not merely currencies or merely digital assets. Now, I want to talk a bit about the existing case law about whether code, or I would say sort of digital assets might not be the right word, but like code and sort of similar technologies that require some sort of interaction to be functional enjoy First Amendment protections. And there's actually quite a bit of it. I have an article coming out in the next, I think probably in 2 months it'll be published, that basically is like a 60-page version of this presentation. And we go through all sorts of case law, but the most important is probably this case called Berenstein from the Ninth Circuit in California. And in that case, it was a PhD student, and this was in the 90s. He was a PhD student who was doing his dissertation on data encryption. So he created an encryption piece of software for his thesis. Now, what he wanted to do was he wanted to then send that out and sort of distribute it as an example of his academic work. What the federal government said was, well, if you send that out, you're violating these arms restrictions on the distribution of ammunition and arms, because it was sort of written broadly. And he said, well, no, I did it. This was a creative piece of expression in academic writing. I shouldn't have to, I shouldn't be censored merely because, you know, you interpret my code as sort of threatening. So this case ended up going back and forth through the appellate courts, and what the Ninth Circuit eventually said, it sort of they had an interesting procedural history, but what was eventually said was, you do have a right to create expression through code. And the mere fact that a piece of code is not regularly understood by everyone in the room in the same way that a poem is, doesn't mean it's any less expressive, doesn't mean it's any less valuable. Now, there was an interesting sort of distinction that they made in this case, where at one point they argued, if you printed out the code and you sent it via the mail, well, at that point, that's just writing, so that would be okay. But if you send something that was more functional, then that wouldn't enjoy the same protection. And that's in a lot of ways like just an insane distinction to make, right? Especially you now have the ability with like OCR. You can write a million pages of code, and in a second I can then turn it into functionality. So like, you know, if you sort of think about like QR codes is a good example of how difficult that standard is to apply. This is a non-functional, essentially a non-functional piece of code, right? If you scan it, and I encourage you guys to scan it because it'll ask you to send me $10 in Bitcoin. But if you scan it, it then becomes functional. So if you agree with this functional and non-functional distinction, then you can really manipulate the regulations, and you can really manipulate a lot of laws in a way that just makes the laws completely worthless. So you're starting to see courts recognize this a little more, but actually with regard to like the computer assistant design cases that are starting to come up, like 3D printed guns, you're now starting to see the functional, non-functional distinction happening again. And actually, this was unanticipated, but like 2 days ago, the SEC put out a statement with regard to utility tokens. And they also sort of started using this language of functional, non-functional to describe at what point does a utility, what point could a token become a non-security if it's part of a sufficiently functional network. Now, I would argue that that sort of test is never going to be easily applied and is never going to result in consistent case law. And that's really what the whole point of our judicial system is that you want to make sure that if you are operating a business or you are taking part of some activity in Florida, then it's not unlawful in another part of Florida or another part of the country. You want to have some consistency, and it's going to take a while for consistency to emerge. So with all of that as background, now let's talk about the more boring stuff, which is regulation. And sort of an example of how regulators are struggling with this type of technology and the results. So this comes from an article that me and a colleague named Arnaldo Rego wrote for a publication called Longhash. And the reason we wrote the article was because they promised to make us this map. But it basically says how every state treats just money transmission as applied to cryptocurrencies. And you'll see all of the different types of treatment. Florida recently just changed, and here's an example of why there's a fundamental problem with how lawyers are describing this and how that's starting to influence judges. In Florida, I think at this point it was maybe like 5 days ago, the Third District Court of Appeal, which is the intermediate appellate court in Florida, had a case called Espinoza I guess it was Florida versus Espinoza. And Espinoza had been accused of laundering money by the state of Florida using Bitcoin and operating as an unlicensed money transmitter. Now, what did he do? He went on local Bitcoin, and someone wanted to pay him money. They are alleging that he knew that it was sort of ill-gotten gains and it was a sting, but he was selling his own Bitcoin for cash. So the trial court said, and this was sort of like a famous trial court opinion about a year ago, well, you know, it can't be money laundering because the money laundering statute doesn't mention Bitcoin expressly. And they also said, and it can't be money transmission for sort of the same reasons. Now, the state of Florida almost immediately after amended its money laundering statute to specifically include virtual currencies, but the position of the Office of Financial Regulation really for several years in Florida was, in order for you to be considered to be acting as a money transmitter, you have to be acting as a third party between two other parties. Meaning, I have to have a business where you come to me and you want me to send sort of Bitcoin. You know, you see a lot of real estate transactions occur this way, where I'm acting as a middleman between two people who want to make an exchange using crypto and fiat. What the Third District Court of Appeals said is, well, no, you don't really need to have a third party anytime you transfer Bitcoin, which they defined as a payment instrument, the same way you would define, a bond or a cashier's check. As soon as you send that to someone else, that's money transmission. So what does that do? That means that there are all sorts of transactions that are occurring every day in Florida that would be unlicensed money transmissions that could subject the transferor to criminal penalties, where the same exact act in Wyoming would be completely legal. The same act in California may be legal. There's sort of like some debate over the exact extent of California's money transmission license. And the same act in New York has always been sort of criminalized with its bit license. I'm sort of oversimplifying the New York position, but I'm free to do that. So there's all sorts of contradictory law that's occurring, and it's all stems from this belief that Bitcoin is money. Bitcoin is a digital commodity. Bitcoin is just what it does and not what it is. Now, and part of the idea behind the paper that I'm writing is to provide this to regulators and to provide this. And there's only that one Mr. Burns picture in it. It's written in a more serious way, and there's something like 250 footnotes. But it's to provide it to judges and to provide it to regulators to understand that when you're regulating this technology, you're doing much more to hinder expression than I think you realize. I'm sure the Third District Court of Appeal, when they were deciding this, were just sort of saying to themselves, well, look, this guy laundered money. He can't get away with that. we're going to decide the case as it is in front of us and not really thinking about all the implications of that. So I'm going to open up for questions in a second. Yeah, all right. But I just want to mention a couple things. What I'm not suggesting is that you can't regulate Bitcoin or transactions on Bitcoin or other similar technologies. The First Amendment is not limitless, but what the Supreme Court has done and the secondary court systems have done is they laid out different tests that you need to comply with in order to regulate. So for instance, a regulation cannot be overly broad, meaning in order to stop one bad act, I can't also regulate away all sorts of other types of speech. You have tests to make sure that there is a sufficient fit, they often say, between the purpose of the regulation and the result of the regulation. So this is something that we haven't seen analyzed by any court at this point with regard to this technology. You also have these rights to anonymous speech that no one really talks about, but I have an absolute right to speak out against the government without the government asking who I am, right? And why is that? This is sort of the checking value theory that we were talking about before. So the application of the anonymous speech doctrine hasn't really been applied to these types of technologies, which are at once financial in nature, but also communicative and associational in nature. Another great example of like the associational sort of protections is if there's been cases involving the NAACP where the government has wanted records of who has donated to the NAACP. They wanted records of who were the members. And the courts have, in every instance, says they don't have rights to this type of information because who I choose to associate with in many ways is protective and a core right that you have as a citizen. Yeah, and I think I'll take applause and then your question. Oh, thank you so much. Thank you. Yeah.
As an accountant, I've gotten really into understanding how every single one of these microtransactions creates a taxable event.
Yeah.
And prohibits people's ability to have this freedom of speech. I mean, how much, and that was actually issued by a regulatory body, the IRS, not by tax law. So my question is how does that 2014 letter that says it's property and everything you do has to be taxed infringe on people's First Amendment rights?
Well, it potentially makes it very difficult for me to engage in specific types of communication. So you can't tax expressive technologies like newspapers, right? Newspapers are exempt from certain taxes because they serve a core function. So there's all sorts of ways you can extrapolate it, but there's a bigger problem that I think you're identifying, which is the IRS has said it was a property. Now, they've never really expanded on that, and they've treated all cryptocurrencies as property. So you have a wide array of technologies that go from, completely decentralized, expressive, sort of associational platforms to completely centralized sort of security issuances that the IRS has just treated as a monolith and said, okay, it's property. Well, why is it property? Because in 2014, we had to make a decision. And we're calling it property. And it's very difficult to get a regulatory agency to do anything, let alone go back on sort of guidance that they've already issued. Now, you see that happening at every form of government. You have the IRS treats it as property. The CFTC says, well, it's a commodity. The SEC, views not Bitcoin, but a lot of, their instinct is to view things as a security. You have states viewing it as states' financial office of financial regulations, often viewing it as money or a currency. So it's like to a hammer, everything is a nail. We're asking these bodies to regulate something, but look at how the internet was developed. Now, I would argue that a lowercase b Bitcoin, the currency, which I need to operate or to interact with the uppercase b Bitcoin network, is not so dissimilar than if I were to go to T-Mobile and buy, some amount of megabytes of data for my phone. Well, it's just allowing me to interact with it. But do you know what the largest payment network in the world is? Not Bitcoin, it's the internet. The internet is a payment network. It's just all sorts of other things. And the reason why we acknowledge that these are all sorts of other things is because we have interacted with the internet in all sorts of different ways. Most people, including I would imagine honestly, a lot of people at this conference have not really interacted with Bitcoin in any way other than currency. And most people are still using their Visa card more than they're using Bitcoin as a currency. So until we really understand what the extent of this is, you're going to have these contradictory sort of regulations. And look, I think it's going to take a whole lot of effort to get the court system, to get the regulators to get on board with this idea. But this is why, like, the lawyers are not the most important people in the space. And there's been a thought that, oh, well, we have to look to the lawyers. We have to look to the lawyers. No, the lawyers are here to service you guys, the developers. What the developers need to do is you need to create applications that, like, my mother can use to interact with Bitcoin, and that courts can wrap their head around about, oh, okay, well, how do you actually use this as a network for association and to expand the ability of expression? That's why I think you can make a lot of criticism about the Lightning Network, for instance, but when I'm talking to people within the regulatory field or when I'm talking to judges and I mention microtransactions and I say things like you can stream money instead of getting paid every 2 weeks, you can stream money, or I can say I can send you a half penny and say I value that statement to half a penny. Well, that's something that they understand. You can sort of conceptualize it. And once you sort of start building out these technology, the expansive world of these technologies, then you can really maybe start making some headway. Yeah.
Would you care to comment on any precedent for either for or against regulation of Lightning Network actual nodes, large ones, that should appear as money service businesses?
Well, again, it's very difficult because the node itself is just participating in a network, especially if it's just to help route transactions.
And particularly from an AML KYC.
Right. Well,
forced to disclose who they're connecting or keep a record.
So there's been several cases trying to challenge aspects of the Bank Secrecy Act. And the Bank Secrecy Act also has AML and KYC sort of issues. Now, the reason why those have not been successful for the most part is because the underlying business was acting as a bank. Now, what does a bank do? Banks facilitate transactions, they make loans, and these often come, the First Amendment challenges often come, oh, just give me 1 second. Oh, I just actually kicked someone else because she was opening the door, sorry. Okay, so what you see these occurring in areas where certain groups have been flagged from accepting, from being allowed to do banking. I think like groups have been supposedly terrorist groups or whatnot. And in almost every case, the courts have said, no, you still need to comply because you are in such a regulated industry, you are acting as a bank. That is something that we view as completely commercial and not really expressive. The bank, you know, it's funny, you have a right to spend money, you have a right to use money as speech, but banking is not actually sort of a protected right. So the law related to like the BSA, AML, KYC has not really been vetted through this technology, and Lightning is something a bit different because I would say Lightning is more associational than anything else, especially when you consider that all we're doing, I'm sending 1/236th of a penny, potentially. Well, you can't regulate the entire Lightning network in order to prevent the possibility of some sort of laundering if it means that all sorts of other protected expression is also going to be sort of regulated along with it. And that is specifically what the it's called the overbreadth doctrine, says, is that if you want to stop one thing, you punish the bad actor who's using Lightning Network to launder money. But you don't say that everyone now has to... Well, no, because banks are specifically chartered with either at a federal or a state or a local level, and as part of that regulation, as part of that registration, the banks are agreeing to certain terms. But I don't think we'll ever get to the point where you have to register as a Lightning node with the U.S. government. So the same argument that you're getting all these benefits as a chartered bank, including FDIC insurance. I mean, that's really one of the reasons that you're getting all these benefits from acting as a bank.
So basically, because it's outside the banking system, it's like they have to.
Yeah, but again, these are questions that have never been thought of by the regulators at any level, let alone the courts who are going to need to interpret them. So, yeah. Is there any other questions or? Okay, thank you.